First up, Anniken Sørlie is a postdoctoral fellow at the Faculty of Law in Oslo. She has been awarded His Majesty the King's Gold Medal for her work. She wrote her PhD on the rights of transgender persons in Norway, and over the past decade, as a student, PhD fellow, and researcher, she has combined the roles as scholar and activist, aiming to strengthen the rights of LGBT persons in Norway. She considers this duality as an important role and part of being a scholar. Anniken Sørlie, we are all ears.
Thank you very much, Asta. I have been asked to reflect on the role of the legal scholar in the world and to draw on my experiences of being both an activist and legal scholar. My experiences and what I address is, of course, influenced by me being a scholar in Norway and at the University of Oslo. It is a privilege to be a legal scholar in a democracy where also the vast majority of the population have positive attitudes towards lesbian, gay, bisexual, and transgender persons, or queer lives, which is the field that I have focused my research on so far in my career. And compared to colleagues in countries where the academic freedom is more at risk, I consider that I am in a privileged position. Research on the legal status of LGBTI persons is, however, often considered as activism and has perhaps a lower status than other fields of legal research. And this makes it perhaps even more important to find the right balance between the role as a legal scholar and the role as an activist, or increases the importance of ensuring that one's legal arguments are strong. In my presentation, I will address two issues that I consider being of great relevance, but also challenging when trying to combine being a legal scholar with activism. Firstly, the expectations from the queer community, or the individuals included in your research. The expectations may be high and perhaps also unrealistic. So how to handle the expectations that the community may have to you and your research? And this is, I believe, also closely linked to the method of combining legal analysis with empirical interview-based data. The second issue is the issue of being true to scholarly tradition and what prevailing law is, and not letting the desire for change leading one to formulate poor legal arguments with little basis in prevailing law. First of all, I consider that using our expertise to the best of others, for example, by working for changes in law and society, improving the lives of vulnerable groups, as our responsibility as researchers. In my view, we should aim at using our academic knowledge for the good of society and, in a way, to give something back. I have focused my research on the legal status and lives of transgender people living in Norway. My interest for this goes 10 years back, when I, as a master's student in law, searched for a topic for my thesis that no one in Norway had written about before, that interested me, and that had the potential of contributing to making a difference for the life of individuals. And this led me to explore the former Norwegian administrative practice requiring surgical removal of reproductive organs for the change of legal gender. And in a way, this was both my start as a researcher and activist, and when I truly began to combine academic work with social engagement. As a scholar, I position myself within the tradition of Nordic women's law, taking the lives of individuals as the starting point for investigating the legal situation of individuals, and in my case, transgender people. Professor Tove Stang-Dahl defined the aim of women's law as to describe, explain, and understand the legal position of women with the specific aim of improving the position of women in law and society. And in particular, I have been interested in how law affects trans persons' lives, how and in what way law matters, and how the law is applied in practice, and how the operationalization of law affects the everyday life of transgender persons in Norway. To hopefully reach the aim of contributing to improving the position of transgender persons in Norway, I have combined internal and external critique of law, drawing on empirical data and queer theory when analyzing law. I've been interested in the power of law and how law works for vulnerable groups and the lives of individuals who are rather invisible in law and perhaps not thought of when the law was written. The lives of queer people and how their lives may differ from the lives of non-trans or heterosexual people has to a great extent been rather invisible in Norwegian law. This may lead to injustice, such as the former requirements of sterilization or divorce for transgender persons who want to change their legal gender. To disclose the injustice and the power of law, to illustrate how it affects lives, and to argue in favor of how law should, and in some cases need to be amended, to better harmonize with human rights, such as the right to private life and non-discrimination, has been key in my work. So in order to take the lives of trans persons as the starting point for my research, I have conducted interviews with transgender persons living in Norway and parents of transgender children, as well as having several informal meetings with people from LGBTI organizations, etc. Interviewing people in vulnerable situations often includes strong narratives about their lives. To mention one example from my study, it included stories about suicidal thoughts and suicide attempts. According to interview participants, this was closely connected to the law and how law was practiced. For example, not enabling change of legal gender or social misrecognition because of being denied access to trans-specific health care. This illustrates that interviews often include stories that affect you, stories about challenges and struggles, and in some cases, this is closely connected to what the law is or how it is applied in practice. It is difficult not to be emotionally affected, but to ensure objectivity is crucial, and to be reflexive and examining and identifying our personal beliefs that may affect the research. Moreover, as researchers, we should have in mind that informants often participate in a study because they hope that it will contribute to change. They expect something from the study. And perhaps, particularly when the researcher is an insider of, for example, the queer community, and perhaps also a legal scholar. It could be that interview participants have unrealistic expectations to the outcome of the research and may expect great changes, for example, that it will lead to a legal amendment, or that the study or a research paper will conclude that an issue is in violation of the law. So in my view, it is crucial to have this in mind when providing information to interview participants and the community. Being open, realistic, and also informing about law may also enable activists and the community to better plan their strategic work. Being an insider of the queer community may be both beneficial and a source of bias when the research aims to improving queer lives or the legal status of queer people. It may be easier to gain trust and to recruit interview participants, and in that way make access to empirical data easier. Being an insider may also influence the knowledge production in the way that the position as an insider and queer activist may have a bearing on what interview participants share with you and influence the research questions. However, it may also make you blind to other considerations. This relates closely to the second challenge or possible pitfall that I want to address. Not pushing the law too far, but being true to legal science, a method, may be a challenge when combining academic work with activism. We need to have in mind that are we ever to gonna contributing to changes that matters for people, we have to be true to legal method and research ethics. We need to be sensitive to what prevailing law is and to distinguish between what the law is and what we want the law to be. I believe that it will help us sharpening our legal arguments, and importantly, it will increase our credibility, both in academia and also towards politicians. Carefully balancing and highlighting conflicting interests and human rights when that's relevant is important. Pushing the law too far may, in the end, harm our possibilities to combating injustice, and our arguments may be taken less seriously and given less weight. To decide change in law and society and being emotionally affected by what interview participants tell us is, for me and many others, an important source of motivation. In order to succeed, I believe it's important to combine this with being true to legal science and research ethics. That will give credibility to our research and the arguments we provide when arguing in favor of strengthening the legal status of vulnerable groups. Thank you.
Thank you, Anniken. Thank you, that was very clear. I find that you seem to have like a very natural relationship to this duality of being an activist and a scholar. If I may ask you a question first, I was wondering, Tarun described a process where he lets the activist choose the topic, and then the activist must, if I quote Tarun correctly, shut up throughout the process, the research process. It is the scholar who's in the driving seat, and then the activist may reappear after publication. Is this something you identify with? Could you talk a little bit about how you see the process?
Yes, absolutely. I think that's a good way to describe the process. I believe that you often start off with this, like as an activist, and you interact with activists and, for example, the LGBTI community, digging and searching for perhaps the gaps in law or the great challenges, the biggest challenges for individuals' lives. And I believe that the way he framed it, in a way, can be used to also describe the two different challenges or the process that I, in a way, was talking about when emphasizing the importance of being true to legal method and what prevailing law is. So that's perhaps, in a way, that part of the process he called, when the activist had to shut up. Yeah. Yeah.
All right. Do we have any other questions? Digital or physical? Yes. This is Malcolm Langford. ladies and gentlemen, from the University of Oslo.
Thanks for a wonderful presentation. So you work in a field which is not just polarised in a binary way, but it's polarised in many directions. I mean, feminism is split over transgender rights, you have the medical community, even conservatism and religion is split because transgenderism can also affirm a binary gender identity. So I'm wondering how you navigate that world. Does it make it even more complicated, or does it actually make it somewhat easier as an academic?
That's a very good question. Well, I believe that it increases the importance of being respectful, and I think that it's very important to have meetings with different organizations, with medical practitioners, for example, that you perhaps disagree with, and to, in a way, also establish trust towards those you disagree with. And I think that if you interact with those you disagree with, you will also it will help you to also find out which argument you have to counter in your research when you write a research paper, and it will perhaps strengthen your work, I think. So, for example, if you write about the issue of whether trans women should have access to women's bathrooms, you should listen to the arguments from the radical feminists arguing that trans women should not have access because it will well, in their view, be a danger for cis women, non-trans women, enabling potential sexual harassment in the bathrooms. I think that if you listen to that argument, it will then you will be sure to write about that position in your research paper and provide arguments why, well, for example, that it has no basis in research for that position, for example, or provide legal arguments against that view. So I think that it will help you to see different arguments and to sharpen your arguments. Yeah. Mm.
All right. I was just thinking when you were talking, because I come from the field of arts and culture, and in arts and culture there's this, I would say maybe the cultural elite has this, is very adamant about separating agendas, political views, those type of things from art itself. They want to keep art pure somehow. Whereas I've never understood how that is possible, because I find that art comes from people. So you are who you are and you bring your lived life into it. So the art that comes out will be a reflection of that. Maybe research is a bit like that as well.
Yes, yes. And I think that that the research will always be influenced by who you are, and yeah, I think it's impossible to separate it completely. Yeah.
And I think the more different people we have who do research, the more we will know about the world, because people see, depending on who you are, you see different things.
Yes, yes. And so I think it will influence the research questions, and yeah. For example, how you see law, what you're able to discover, whether you're able to discover gaps. So I believe that a queer person and a non-queer person may see the gaps differently, may discover different gaps. And that means that we, for example, need both queer legal scholars and non-queer legal scholars working on the same issues, I think.
Thank you very much, Anniken Sørlie.